Welcome to Plan On It.
Welcome to Plan On It with attorney Christopher E. Botti, board certified specialist in estate planning, trust and probate law, and founder of Botti and Morrison Estate Planning Attorneys. I'm Leanne Lyon, and today we're looking at one of the biggest reasons Californians create a trust in the first place: to avoid cost, delay, and publicity of probate. Chris, for anyone who's heard the term but isn't quite sure what it means, what exactly is probate and when does it apply in California?
Okay, probate is a charged term in California. When people usually hear the term probate, their eyes will roll if they've ever been through it themselves or have had to go through it with a family member. So probate is what happens to your estate when you die. And so it's a formal procedure of the Superior Court, and it has several implications if your estate has to go through probate.
Well, why does probate have such a bad reputation? Is it the time, the expense, or something else that families should understand?
There is a laundry list of reasons why probate is something you absolutely want to avoid in California. Number one, the first reason is it is a formal procedure of the Superior Court, and therefore there's a certain time component to getting a probate case completed. The average probate in California takes about a year from start to finish to get completed. And that's assuming there's no litigation or disputes over the validity of any documents. Probates can go on far longer than 1 year when there's potential dysfunction or disputes over the validity of an instrument like a will, for example, or creditors fighting over assets and stuff like that. So if it's a fast track probate, it takes about a year. That's a long time, right? So that's frustrating. During the period in which the state is being administered, there is a freeze on all assets. So nothing gets distributed until the very end of the process. That creates a lot of frustration for the family because someone's passed on and they're going to have to wait a year or more in a lot of situations before they'll get any assets out of the probate estate. It's a public procedure, which means anybody can pull a probate file and look into the file and see intimate details about a person who's passed family. For example, the name and address of all the heirs mentioned in the probate case, including, addresses, telephone numbers. You get a detailed inventory of all the assets that they own down to the sterling silver knives and forks. It's there for anybody to see. You can go pull a probate file. It's a public proceeding. So it's frustrating because it takes a long time. During the period of administration, the assets are frozen. It's a public proceeding. And of course, the kicker ultimately is the cost of probate. That is the ultimate deal breaker for most people.
Well, just the privacy aspect of it really just hits me. But I know you mentioned in that a will, and many people assume that having a will keep them out of probate. Why is that a misconception in California?
Well, before I get into that question, I never got to the actual typical cost of a probate. This is shocking for a lot of people because when they calculate the fees that go to the attorney and the executor of the estate, it's based upon gross asset values. So for example, if you have a $750,000 home with a $500,000 mortgage on it, if you sold that property while you were alive, you'd net $250,000. And so that's the net equity. But for probate purposes, they don't calculate the fees based upon the net asset values. They're based upon the gross asset value. So the probate cost is based upon the $750,000 number, even though the family, if the property was sold, would only receive $250,000 with a $500,000 mortgage. So that's insane, right? And so the system is totally skewed in favor of the probate attorneys who benefit from the system. So a typical probate case, modest estate, $500,000, would roughly have, I'm going to make available for everybody to check out a chart we've made that really demonstrates the cost of probate on all the different levels depending on the estate size. But a typical estate of $500,000 would result in $26,000 in probate costs and expenses. That would go half of that to an attorney and half of it to the executor. That's an insane amount of money, far more than the cost of doing, for example, a living trust to avoid probate, which we're going to get to, I'm sure, in a few minutes. So wills, getting back to your original question, wills trigger probates. So if you die with a will, under the California Probate Code, wills must be probated. That's what the law says. And if you die without a will, of course, your estate is also going to be probated. So wills alone are not going to get you to the promised land. You're still going to have to go through the process.
So, in practical terms, how does a revocable living trust help a family avoid probate while still giving them control during their lifetime?
So they both do the same thing. Like, when I die, here's where my stuff goes. A will does that along with a trust. The only difference is a trust is an entity, a revocable living trust, that you establish while you're alive. And so it's treated as a separate legal entity. And when you pass on, that entity still exists for the purpose of distributing your assets. And so what happens when you pass on with a trust, a successor trustee will take over and step into your shoes and now become the manager of the trust. And through that trust, they can distribute the assets of your estate without any court supervision whatsoever. So that's the beautiful thing about a revocable living trust, is it doesn't get the courts involved at all. This whole process is handled privately within the family, and we don't have to get the probate courts involved in any aspect of the administration because the trust avoids that.
I know I've heard this term around trust. It's the trusts only work if it's properly funded. What does funding actually involve, and what tends to get overlooked in that case with it?
Well, funding is critical because a trust by itself doesn't really do anything unless assets are actually owned by the trust. And the way you have assets owned by the trust is by, for example, with real estate, a deed would be prepared transferring your home to your trust. And that would be recorded in such a way that the county recorder's office would consider that a trust asset. And so with real estate, it takes a grant deed, which we would prepare on behalf of our clients to transfer a home into a trust, for example. And then with brokerage accounts or bank accounts, what you do is you contact the institution that you have an account with and you ask them to retitle the account in the name of the trust. And so paperwork is submitted to them, and then the institution updates the records, and you can tell that your bank account, for example, is in the trust, or your brokerage account, for example, is in the trust, because your statements will now have the trust name on them. And so the process of funding is critical, and that's done post-execution. So once you sign the trust, you're not done. You have to follow through with the funding process. And most attorneys who do this will handle the real estate component, because that's critically important to do correctly. Because when done correctly, it doesn't mess with the property taxes. In California, we have this thing called Prop 13. You maintain your Prop 13 property tax basis if you transfer your property to a revocable living trust. It doesn't interfere with your mortgage if you have a mortgage on the property, but the deed needs to be prepared correctly. That's usually up to the lawyer to do that. So we will handle that for our clients. With bank accounts and brokerage accounts, it's a matter of just the client reaching out and contacting the institution and getting whatever paperwork they may need in order to update their records to make it a trust asset.
Well, you caught one question. I was real curious if you could put a real estate property with a mortgage on it into a trust. That's good to know. But what happens when somebody forgets to move an asset into their trust? Is there a backup plan, or does that asset still then have to go through probate?
That would be a mistake. We try to avoid mistakes at all costs, right? But we have plans to deal with mistakes. Now, it depends on the size of the mistake. So in California, we have a threshold for what they call a full probate. So if it's liquid assets in California, if the value of those accounts that are outside the trust because you've made a mistake and didn't put it into your trust is below $208,850, which is a nice round number that adjusts for inflation every 3 years. But if it's below that threshold, then all you need to do is present what they call a small estate affidavit to the institution. And under California law, they have to release the funds to the trustee of the trust. So little mistakes are not problematic. They cause a little bit of delay, but ultimately it's handled. And then with larger mistakes, over that $208,000 mark, then you could potentially, even though you have a trust, also have a probate. Now, what we do with a revocable living trust is, even though you have the trust as the centerpiece of your estate plan, that's the document you look to figure out where everything goes, you still do a will, but it's a special kind of will that works in conjunction with the trust. It's called a pour-over will, and that's for mistakes, basically. And so what that will say is, if I make a mistake and I fail to put an asset in my trust, I leave that asset to my trust to figure out who gets things. And so that's how we make sure the trust will be the distribution vehicle for mistakes. We don't want to rely upon the will, because wills could trigger a full 1 year probate and have that expense that I referenced earlier attached to it. So proper funding is absolutely critical, and it's very important that you engage in that process once you execute your documents.
Sounds like you thought of almost everything in there. That's awesome.
Well, again, we have to be comprehensive because there's a bunch of documents that make up an estate plan, and they work synergistically together. And so it's really important that it's not just the trust you're doing, that you actually have a will just for that potentiality of making a mistake, which again is something you don't want to do, but stuff happens. People get older. Sometimes they forget. They open up a bank account. And they forget to put it in their trust, and then something happens. They pass on. We have workarounds. We hope never to have to deploy the full workaround, which is a probate when you have a big mistake. But if done correctly, you can eliminate the need to get the courts involved completely with just funding the trust.
Well, in California, I know that there's a community property system. And how does that affect the way married couples own their assets and plan to avoid probate?
Well, with community property, it's common in community property states like California, and there are 9 total states that have community property, that married people will do what they call a joint trust. Back east, in what they call common law states, it's very typical that each spouse will do their own separate trust because it's not a community property state. But in California, because we have community property, typically married people join forces and they create one document, which makes it easier to do this because it's just one document versus 2. And you use the community property laws to allow that to work synergistically with one trust.
Very cool. Well, beyond saving time and money, what other advantages does avoiding probate provide, especially for families who value privacy or want to prevent disputes?
Well, the key is like peace of mind, right? You want to make sure that when you pass on, you've worked so hard to accumulate what you have, that your assets get to your family, to your heirs, free of any court process if possible, because the court process is incredibly expensive. The cost of probate is incredibly expensive. It's frustrating. You're providing a venue for potential disputes when you have to start off in court in order to administer an estate, whereas a trust is purely a private matter, and you can keep the entire thing within the family. And ultimately, at the end of the day, that's what it's all about, like keeping the family in control and not having to get the courts involved with the distribution of your assets. It's totally unnecessary. See, the system of probate was designed for people who fail to plan, right? California has probate in place for people who don't exercise their rights and opt out. And the way you opt out in California, it's very simple, is with revocable living trust.
Without naming names, of course, or getting too specific, can you give an example of somebody who didn't properly fund their trust and ended up going through both systems at the same time? And how did that work out?
Well, the classic example is involving real estate, where you purchase a property after your trust is executed and the deed is prepared and it's not transferred directly into the trust. And so you pass on not knowing that that property is not in your trust. And now you've got to get the probate courts involved in order to get that property into your trust. And there's several ways you can do that, but if bottom line is it involves a court procedure, right? So it happens typically when people purchase additional real estate once they execute the trust, and for some reason they just don't tell escrow. It's part of the vesting instructions, because you can take title a number of different ways. Put it in my trust, and they never realize they made a mistake, and there's no way of knowing it until they pass on, and then boom, you've got a problem. So the probate in that case would only be as to that particular mistake. The entire trust doesn't get sucked into the probate procedure. It's just the assets that are outside the probate, outside the trust, that potentially get caught into a probate procedure.
Well, as we wrap up for today, and for listeners who already have a trust, what's a good way to confirm that it is properly funded and up to date before assuming that they're fully protected?
Well, the best way to do is create an inventory of what you have. The best thing you can do is create an inventory. So starting with your home, you can tell that your home is in the trust by looking at your tax bills. Every single year, you get a tax bill for property taxes. And if it's in the trust, your tax bill is going to say the word trust on the tax bill. So that's a telltale sign. And you can also, if you have a copy of the deed that was prepared and recorded, putting your property in the name of the trust is another way to prove that it's in the trust. With bank accounts and brokerage accounts, your statements are the telltale sign. So when you properly fund a trust with a bank account or a brokerage account, your statements from that point going forward, whether they're done electronically or through snail mail, your statements are going to have a reference to your trust as the owner of the account. And that's how you tell. So the best way to do this, and every year you should go through this exercise, maybe at year end, because it's like gearing up for tax season. So it's a perfect opportunity to do this. Make a list of what you have assets wise and make sure that they're titled correctly. And if not, you can fix it very easily by just contacting the institution, for example, if it's a bank account, and saying, oops, I've got this account, I need to put it to my trust. And so you make an appointment at the bank and they will update their records and it'll be transferred to the trust. So it's just doing an inventory. It's house cleaning. You should do that frequently, once a year, just to make sure that your trust is properly funded. That way you avoid these mistakes that lead to this probate process, which is incredibly frustrating and expensive.
Well, thank you, Chris. This is valuable information. And that is it for today's episode of Plan on It with Christopher E. Botti. If you'd like to learn more about protecting your assets and keeping your family out of court, visit boddilaw.com to download the free 2026 Medi-Cal ebook or register for a Botti and Morrison estate planning workshop. Thanks for listening, and remember to like, subscribe to the show, and share this episode with somebody who might need it.
Thank you.
If you're enjoying Plan on It, be sure to subscribe, leave us a 5-star review, and like the post. Share or tag friends and family who could benefit from clear, practical estate planning guidance.